Hey everybody, it's your boy Captain Hunter coming at you again. Thank you so much for taking the time out of your busy schedule to check out this particular video. Think I got a good one for you. We're going to talk a little bit about Miss Tiffany Henyard, and we're going to talk a little bit about qualified immunity. And I'm going to try to link these two together. So this is not a bait and switch. So just stay tuned and all that. Grab your popcorn, and we'll try to make this through this. This will not be a long video. So I want to talk about. I want to start this off with a video that I did talking about why experts disagree in police shootings, and I'm pretty sure. Yeah. So there's a few comments here that I want to get to, and this guy user GX2YY1DF6F. Ask a couple of questions, and I don't know if he's asking these in good faith or he's just kind of trolling, or if there's he really wants to start an argument or debate or whatever. But I'm up for it. As they say, I got time today, so I am going to try to answer these questions. I'm going to assume that these are all in good faith, and because I want to give information, because there's a lot of misinformation out there, right? There's just a lot of bad misinformation. People think that they understand things. People think that they know what the police can and cannot do, and all this type of thing. The first and foremost thing that you really need to understand is that the police set their laws, set their rules, set their regulations, set their policies, and set their procedures based on the laws, the city laws, municipality laws, the town ordinances. They'll set their policies, again, based on state laws and constitutional laws. Constitution comes first, right? This is where we get Tennessee versus Garner. This is where we get use of force. This is where we get Graham versus Connor. All these different types of use of force laws, right? The Constitution, Fourth Amendment, search and seizure, Eighth Amendment, your right to, not excessive force, bail, cruel and unusual punishment, all this type of stuff, right? Fifth Amendment, you have the right to incriminate yourself when you're in interview and interrogation. 14th Amendment, all this different types of amendments, right? I'm not going to take you down the constitutional program here. But so that is what sets the laws. That's what sets the terms. Second part about that is, right, then you go to state law, state constitutions, right? This is why laws may be different in how they do things in New York State versus Connecticut versus Ohio versus California versus Texas versus Alabama. All these things can be different. And then you can go from municipality. Your police department is generally arresting you based on state laws, and they're arresting you based on probably some city or municipal town ordinances, right? Not taking your trash out or things like that. They can give you fines. Staying in a park after dark generally isn't a state law. It's generally a municipal or town ordinance or county ordinance that is designed, but it's usually not something that they can arrest you for. It's usually a ticket, and if you refuse to sign a ticket, then they can take you to prison. There was a good, I think it was in Atlanta, Georgia, there was this officer who tried to arrest a young lady, or tried to give a young couple some tickets for staying in the park after dark. And then when the young lady refused to sign the ticket, then he had taken her to prison, and then the fight ensues and all that kind of stuff. It was actually very informative about how the police get down. I know people don't want to hear that, but all that. All right, so I'm going to answer these in the kind of the order. Maybe I'll go from the bottom up. I think I'll go from the bottom up because I would assume that the later ones are the ones at the top. Are the ones at the top. Let's see. Maybe not. Let's see. Okay. We'll start with this one. Now, I'm assuming that people have watched the video. If you have not watched this video, why experts disagree in police shootings, then you need to go back and review what I said. Therefore, he's responding to what I said, obviously. It says, I guess it, I don't know what that's supposed to mean, if I'm an it or maybe the video. It says the officer was listening at the door for fighting or arguing. Okay, so what would he have done if he heard arguing? That gives the officer reasonable suspicion and or probable cause, because then he or she, any officer in any place, can then go in their report or put down in the report, I listened at the door and I heard signs of arguing. If there was signs of really, really bad arguing where, you hear TVs being smashed, lights being knocked over, things like that, that gives the officer the right to boot the door, kick the door open because he fears that someone is in imminent danger. In that case, probably knocking the door, hey, police. They refuse to open the door. Now they can boot the door because they've taken the time to listen at the door. I'm drying some clothes there. I hope that that's not audible, but that's what, if you hear that, forgive the lack of professionalism. I'm drying some clothes and I realize how loud it sounds. So hopefully that's not coming through. Knock on the door, be more prepared. I guess that's sarcasm right there. Well, yeah. Again, police officers would then in that scenario, if they would be more prepared, they would understand that there's a certain level of violence going on, and yes, they're going to amp up what I'm calling their spider sense, and be more prepared for what's on the other side of the door. So that may have been sarcasm, but yes, there is a certain level of preparedness. Should all officers walk into any scenario, any situation, and have a level of preparation because things can go from 0 to 100 real quick? Of course. But now we know what it is. It is what it is. Well, he didn't hear anything, so now what? So now he knocks on the door. I mean, I'm assuming you watched the video, Mr. User GX. I'm assuming so now he knocks on the door. Okay, he doesn't hear anything, so he can't put that in a report. I locked on the door and I didn't hear anything. Is his approach going to be different because he heard nothing? Again, you still should have some sense of awareness, some sense of spider tingling going on because of what we're going to talk about a little bit later. I know that was sarcasm. Totality of the circumstances that he being the officer talked to a woman who said there might have been fighting going on. He was already dispatched, and because he heard nothing, maybe there is nothing going on. Maybe this is just a big nothing burger. But this is all based on training, time, and experience. I know this may seem unpopular. I'm answering these questions because I think that while there may be a certain level of sarcasm and disbelief, as if officers just do what they want to do, there's training and experience that have gone along with this. And this is years and years of research. They've talked to officers who have been ambushed. They've talked to officers or they've investigated and figured these things out. So not just officers just making things up as they go along. People want to assume that, but this is years and years of research, watching videos, watching body cameras, watching dash cameras, interviewing officers who have been ambushed, jumped, even investigating those officers who unfortunately lost their lives in the line of duty. And once they have completed their reports, their analysis, this is how they decide or the best method is of going forward. Isn't it an exact science? No, because every situation and every encounter is going to be different. But you have to make the best preparation for the next encounter that you can. It doesn't appear so since he was there with his gun drawn. I haven't seen where his gun was drawn. Now, maybe somebody else can see something different. Officers will have their hands on their guns, on their weapons, in case something goes wrong, and so they can quickly, snap off and get access to it. Yeah, because they don't know what they're walking into. We've often seen that on the side of the road with officers in motor vehicle stops. Why is their hand in the gun? People ask the question, why is his hand in the gun? Well, I'm telling you why. Because they don't know how quickly somebody can be sitting in the car and then quickly shoot over their shoulder. It's quick. So therefore they come with a certain level of preparedness and all that. His gun was going to be drawn either way. I don't think that officers can just walk around. That's going to depend on policies, but their guns aren't just drawn either way. Now, again, I'm asking the question: how do you know his gun was drawn? It's not in the video, so I haven't seen that. I haven't seen that, and that's not my assumption. People may be assuming that because of the quickness and the speed that which the officer was able to get up on target and start firing, that was the case, but officers are trained all the time I did it all the time to get my weapon out. How fast can I get my weapon out? Because I don't want to be caught slipping. So I'm trying to give some information here. Police paranoia has gotten more than one person killed. Dan Shaver. Listen, I'm not saying I am not saying that officers are not operating, going under some certain level of fear and paranoia is probably the wrong word. Paranoia means that you're scared because you think somebody's after you. Well, police have been ambushed, so it's not like it's extremely paranoia. So, and if you did light that dude up, you would have been wrong, and you still would have walked. No. So this is where I wanted to, he's going to talk about the qualified immunity up here. Oh, yeah, you guys can see where I'm highlighting that. So I want to try to light this. I want to try to get this into here. I'm not exactly sure what monopoly of force, what this author means by that. I think he may be meaning that the state has regarded the use of force for themselves, and that would be correct. If that's what he's talking about, then that's true. The state has authorized itself. I'm not saying whether it's right or wrong. I'm saying it's authorized use of force for itself, unless, of course, somebody's in a force situation, then they can defend themselves. You do not have the right to aggress. You do not have the right to aggress, but you do have the right to defend yourself in case aggression has come your way. So, and if you did light that dude up, you would have been wrong and still would have walked. So I gave the story about the time when someone had called the police and they had come down and they thought someone was breaking in their house. And next thing you know, somebody had run outside and they had their gun pointed, and the officer, and because of my angle, I'm standing off at a 90-degree angle. My partner was in the direct line of sight of the person who was pointing the gun. So if I would have drawn up and then started firing at this guy, I would have definitely been in the right. I would have been in the right because I would have been, in my thought process, defending the right of the officer. Now, here's where people tend to be money morning quarterbacks and don't really understand the complexity of what we're talking about here. The question that always has to be answered is did the officer act correctly? Right? In any shooting case, any use of force case, did the officer act correctly? That's the answer that the state prosecutors, state prosecutors, county prosecutors, that's the question that they're asking. In the frame of mind of the officer, did they act correctly? And you can listen, you can talk to prosecutors, you can ask them, right? Here's some knucklehead cop on the internet saying this, that, and the other. Hey, you're a prosecutor, what's your thoughts, right? The analysis comes from the actions of the officer on the information that they had at the particular time that they fired the weapon, used the baton, used their OC spray, or used their taser or whatever, or sick the canine on them, whatever it is. What did the officer know, and why did they take the actions that they did? And was that use of force justified given the law and given what other officers would have done in a similar circumstance? Those are the questions that people go to court and ask. Think about the whole George Floyd incident, and the officer there, his name is escaping me, his name really isn't relevant, right? That was the analysis. The analysis that the courts used is when they took experts, other officers, analyzed the amount of force that was being used, the length of time that the force was being used, the level of resistance that George Floyd was offering. Was that force reasonable? Would another officer, given the same set of circumstances and given the same application of the law, use the same amount of force that Derek Chauvin would used? The answer is no. That's why Derek Chauvin is doing 20 years in prison, because it was deemed that his level of force exceeded the normal parameters, state law, federal constitution, and what another reasonably trained officer would have done in those circumstances, right? So that's why he would have done that. So, and if I did light this dude up, given the scenario, the story that I give, I would have been wrong. I would not have been wrong. Unfortunately, you're wrong. And I'm doing this not because I'm trying to pick on somebody who doesn't understand, but I'm trying to give information because I think that a lot of people think this way, and I'm trying to correct the way that they're thinking. Okay. I'm not sure what these comments mean. Do you believe in Easter Bunny and Santa Claus too? Yeah, they make stuff up. Yeah, all that make-believe stuff like justice or liberty. I think these might be people who are kind of anarchists. You say the cop You said the cop made a split-second decision. I do say that. But the cop knows he has qualified immunity. He knows that he can shoot and be wrong and nothing will happen to him. He knows this. And why does totality circumstances work for us, but police? We don't know if the guy had a beef with someone who threatened him. Okay, so I want to try to get to this question of qualified immunity, because I know people might have tuned into this because of Tiffany Henyard, and I want to try to link this to Ms. Tiffany Henyard. So qualified immunity, we're gonna go over here for a second here, because a lot of people think that they understand what qualified immunity is. And you can see I got this from the National Conference of State Legislatures, right? This is not a police website. This is not, I'll try to shrink this down here so you can see everything here. I want to do my due diligence here. Okay, so make myself a little bit bigger here. Let's see. No, not that big. All right, we'll go up here. Block out my signal there. All right, so the doctrine of qualified immunity. Again, this is from the National Conference of State Legislatures, right? It's a foundation. So, I mean, you can Google this, you can go and research, right? So you can choose whatever website you want, right? This is 2021, right? This is after George Floyd, right? George Floyd is 2020. The doctrine of qualified immunity protects state and local officials, including law enforcement officers, from individual liability unless the official violated a clearly established constitutional right. The evolution of qualified immunity began in 1871. Who knows what was going on in 1871? Anybody want to know? Take a gander at what was going on in 1871? Oh, yes. We were under the. Actually, this is about to be the tail end of the Reconstruction era after Civil War, right? And all that. So the federal courts adopted this law because they wanted to protect who? Oh, yes, the newly free black slaves, well, formerly black slaves. They want to protect those particular citizens from who? Oh, they wanted to protect them from public officials who were not treating them correctly. And we could include Asian Americans at that time, natives, all these different people who were now trying to get into the family of America until, of course, the end of Reconstruction. Then we get Jim Crow and all that kind of stuff. So that's a whole different story that we can go down. The evolution of qualified immunity began in 1871 when Congress adopted 42 U.S.C. 1983. This is the law that people still, when lawsuits going on, these are 1983 lawsuits, which makes government employees and officials personally liable for money damages if they violate a person's federal constitutional rights. State and local police officers may be sued under 1983. Until the 1960s, few 1983 lawsuits were successfully brought. I wonder why that is. Oh, because all the public officials were in on it until the 1960s when they said, listen, we've had enough of the riots. We've had enough of the Jim Crow. We've had enough of this. It's time to bring Black Americans and all Americans into this family that we call America. So they were suing all across the way. I have a book here that really is good, talking about how they finally overturned, I can't seem to find it, how they finally overturned segregation in schools, 1954, 1955, overturning Plessy v. Ferguson and all that. I don't know. I can't find it. In 1967, the Supreme Court recognized qualified immunity as a defense in 1983 claims. In 1982, the Supreme Court adopted the current test for the doctrine. Qualified immunity is generally available if a law enforcement government official violated isn't clearly established. In other words, before you can sue someone because they have and they are able to accept or given clearance, or I'm trying to make I'm not a lawyer, so the correct verbiage that they say that goes along with this is eluding me right now, but they qualify for qualified immunity. Essentially, is that the law has to be clearly established. some people, when I read another website, they were talking about, some kind of precedent or anything. But I'm gonna stick with this. It has to be generally known or well known within the Constitution, or established in the Constitution. This is wrong, or established within the legal circles. So again, think about George Floyd in that particular situation. And by the way, to answer, whatever his name is, user, whatever he is, there have been plenty of police officers who have been sentenced to prison time. There are police officers, former police officers right now doing prison time because they violated established law, policy in the Constitution. They used extreme excessive force. Here, another case was for you. Again, I don't know all the particulars, ins and outs. But you think about the Rodney King riots. They were tried in state court in California. They all got off. It was the federal courts that got them, right? Because again, these laws are only as good as the people who are enacting them, who are bringing them, who are enacting them, and sitting on juries. That's why you must sit on juries, and that's why you must vote. If you are a citizen, you must vote. And you must sit on these juries. Stop trying to get out of jury duty, because you will have a chance to change and to direct where you want your government to go. So George Floyd, the Rodney King trials, these people established clear use of force parameters, protocols, the right to not be abused. Search and seizure. The federal government has established that search and seizure is or killing by the state or by police officers in particular is the ultimate type of seizure, and they don't have that right to do that unless it is absolutely completely warranted. I hope that all that made sense. If qualified immunity applies, money damages aren't available even if a constitutional violation has occurred. If qualified immunity doesn't apply, while the government employee or official technically is responsible for monetary damages, the government entity virtually always pay. That's the idea of deep pockets. So qualified immunity protects state and local governments from having to pay the monetary damages, yet not deemed unconstitutional by the court. The qualified immunity doctrine is very favorable to states and local governments. Clearly established means that at the time of the official's conduct, the law was sufficiently clear that every reasonable official would understand that what he or she is doing is unconstitutional. According to the Supreme Court, a qualified immunity protects all except the plainly incompetent or those who knowingly violate the law. So what they have to be doing is knowingly incompetent. Take, for example, or a clear violation of the law. Remember when cell phone cameras came out? And these officers were arresting people, and they were, for video recording them and all that. It was not clearly established that they would that the videotaping of citizens videotaping by citizens of the police was clearly wrong. It took numerous court cases to say, listen, knock this off. The police, when they're doing and performing their duties, have a right to be videotaped. At those particular different times of state interventions, state laws saying it, state and federal courts coming up with these different procedures. Now today in 2024, if somebody says, if a police officer says, listen, don't record me, and snatches your camera out your hand, slams you on the ground, then I would say that's clearly, it's clearly a violation of the law. Unless they're plainly incompetent, or they have to know now by training and by experience, by court policies and court procedures, that citizens have the right to videotape where you are. Granted, you got to be standing a certain amount of feet back. Don't interfere. Don't talk or all that. If you're going to say anything, say, okay, we're getting you on tape, or you can say, or you can tell the offender to stop doing what they're doing. But anything absent of that, I think you're asking for trouble. That's just my personal opinion. The Supreme Court has offered multiple justifications for qualified immunity, including that it encourages government officials to unflinchingly discharge their duties without worrying about being sued or for actions the court has not yet held violate the Constitution. Again, I think that my example about that is solid. All right, so let's get back to this guy. You said a cop has to make split-second decisions, but the cop knows he has qualified immunity. He knows that he can shoot and be wrong and nothing will happen. He knows this. What he knows is that he has to operate within the boundaries of the law, that he has to be able to clearly articulate that there was a threat to him or to her. Simply saying, I hear this all the time, simply saying that, I fear for my life is some type of get out of free jail card. Again, there are multiple police officers in multiple states who have tried this and said I was scared and whatever, and they still were found to be wrong, and they still got in prison time for this. So don't follow these type of people and all that. But they do, as the last article that we said, they do want officers to be able to act with to be unflinching, right? To not to be scared, not to have to back down, not to have to second guess themselves, and to move with that. So as long as you're acting, as long as you can clearly articulate this, anything that comes along, then that's what it is. So then you would qualify for qualified immunity, or qualified immunity would attach itself to that particular case. So last question here, then we'll get to Ms. Tiffany Henyard, because she is a government official, is she not? Why does totality of circumstances work for police but not for us? It does. I don't know why you would think that. And here's a response: monopoly of force. I think that what they're saying is that under these circumstances, I think that under these circumstances, that the state reserves the right to use force. So, again, you can use force to defend yourself. You cannot use force to aggress, right? To attack, to aggress, but you can use the force to fend off aggression. Work for us. I don't know. Give me an example where it doesn't work for you in a self-defense scenario, right? You are walking down the street, you see a guy with a big dog, and he's looking at you mean, and he starts whispering in the dog's ear. Next thing you know, the dog starts charging at you. You take out your firearm and fire at the gun at the dog. Would you be right? Of course you would. You can assume that this guy whispered something in the dog's ear. You could be walking down the street. You could see a guy with a baseball bat. You duck into an alley, maybe to use the bathroom and make a phone call or whatever. You see the same guy walking around following you with a baseball bat, kind of hitting his hand with a baseball bat, tire iron, you name it, a knife. And then next thing you know, he's following you with different blocks, right? This is building up what we would call the totality of the circumstances. Here's a guy, he's following me from block to block, following me down alleys. He's not talking to me, he's just eyeing me. I don't know if he's eyeing me up to take what I have. I don't know what he's doing. But in those circumstances, you can still do whatever. And the next thing you know, he's standing next to you with this thing. He jumps out of a corner. Would you be okay with hitting this guy in the face? Maybe not killing him. Maybe, depending on his size, you still might be able to get away with this. So you still have to be able to articulate that this person was a threat, and here's the difference that people often don't get, right? Some states have it, some states don't. Florida doesn't have a retreat rule. I don't think that any state has it when you're in your own domicile. But any time that you have the ability, capacity to get away from somebody, because anytime you have the ability and the capacity to get away from somebody, then the state wants you to take that. Some states want you to take it. Some states say hold your ground. They want you to get away from that, to get away from the individual, right? Because they don't want you taking people's lives, because you could be wrong, right? You're not a trained individual. But we ask our police officers, we pay our police officers to go into situations, to knock on strangers' doors, to go down dark alleys, to pull people over in the middle of the night at 2:00 in the morning when it's completely pitch black. We ask our officers to do that. We are intentionally putting our officers in this situation. And so we have to, and the courts do this, I don't know if I stressed this enough, but let me stress it now. When the courts are looking at the conflict that happened, I think I did talk about this. When the courts are looking at the conflict that happened, they're looking at it from the police officer's point of view and trying to determine what happened and was this justified. And they at that time, they will take the totality of circumstances. Again, if somebody kicks in your door, you can say totality of circumstances. This guy kicked in my door. I don't know who he was, so I started unloading my piece into him. And I think that as long as you can articulate yourself is why you felt that there was a certain need for that, right? You can't just be scared. It just can't be a big black guy. It just can't be some man and you're a woman, right? In those cases, you have to try to escape from that person because you could be wrong. You don't have to be in that situation. You don't have to run if you're in your place of work. Most states would say that. You don't have to retreat when you're in your place of work, and you don't have to retreat when you're in your home. Some states say you can hold your ground in the middle of the corner. You fight with your local people about that. So I think that I've addressed that well enough. So let's go back to Miss Tiffany Henyard and see if this qualified immunity is taking anything for her. Is going on for anything for her. So I found this to be interesting. This is a couple of days old now. I tried to make this video yesterday, and I was having computer problems. I had to go buy new pieces for my computer and all this kind of stuff, right? So Dolton, Illinois appoints mayor pro tempore amid corruption scandals, FBI subpoenas, right? So they're getting ready to get rid of this lady. They are getting ready to get rid of this lady, right? So I guess there was no second in charge or succession process, so they had to vote somebody in, or maybe this was it, you know. The Dolton Village Board of Trustees voted Monday night to appoint a mayor pro tempore. Trustee Jason House was approved as mayor pro tem at the village board meeting Monday night. In the position, he could fill in for the mayor in certain situations. He could. I think that's interesting. Not that he is, but he could fill in certain situations, right? In case something goes down, they got somebody in the place. We're really just trying to make sure that if something critical comes up, wink, wink, hint, hint, there's a signature on deck that can move forward, House said. Dolton Mayor Tiffany Henyard did not attend the board meeting Monday night. Henyard is under investigation amid a series of allegations of impropriety and corruption. So based on what I said, based on court laws, based on the definitions that were given about qualified immunity, do you all think that Ms. Tiffany Henyard qualifies for qualified immunity, right? Qualified immunity protects all except the plainly incompetent or those who knowingly violate the law. And it would be my assumption that she's the mayor. She should know, she knows, or she should know what the law is. Are they going to let her up because she's incompetent? I'm not a lawyer. I am not a lawyer. Let's see. Let's see. The FBI recently served 2 subpoenas to the village, and the probe, many believe, centers around Henyard and her lack of transparency. The board had hired former Chicago Mayor Lori Lightfoot to investigate Henyard. Last week, Henyard vetoed the plan, saying, "How dare you think you can come into someone's town and investigate? You will not get paid." Other scandals have plagued the South suburban village lately. A former village worker claimed she was essayed by the village trustee while the village funded a trip to Las Vegas. So she's got some issues, and they are preparing for those issues, right? And so the crisis responder here, right? Crisis responder Andrew Holmes fired by Chicago survivors for alleged essay. Now, here's why I think that this story is interesting, right? Because he may feel the pinch around him, and if he's losing jobs and being, he's still on the board. I believe that he's still on the board. If he's starting to lose money, starting to lose jobs, starting to lose reputations, he may be a target for the FBI to flip and to talk about what's going on. So I can imagine that Miss Henyard is starting to feel the walls close in around her. Dolton, a community activist and Dolton trustee, has been terminated from his role as crisis responder with a Chicago organization. Holmes was fired by Chicago survivors in April. After SAS allegations were brought against Holmes and a lawsuit filed against him in the village of Dolton. When is this article? I just thought I just read it the other day. When was this done? Oh, May 6th. Yeah, May 16th. Why did I talk about April? I know it was pretty recently. Chicago Survivors Executive Jashawn Hill issued the following statement about Holmes. Our mission is to provide crime victims services to family members of homicide victims, so our relationship with those families in our community is paramount. Without compromise, there needs to be strong mutual trust and an assumed high level of safety for the adults and children we serve. For those reasons, we terminated his employment in April upon learning of the serious allegation. Fania Dukes filed a lawsuit and said that she was fired after taking the essay allegation to Dolton Mayor Tiffany Henyard. Earlier this month, Dukes spoke at a Dolton meeting about the essay that she endured from Dolton trustee Andrew Holmes during a village business trip to Las Vegas. This is overwhelming, Dukes said. I'll survive. This means so much to me, but I still want everybody to know I'm standing with you too. In edited video provided to ABC News, Duke described how she lost trust in Holmes, a well-known crime victims advocate. I guess so, if he's taking pictures of you and putting them up on the internet or video conference calls. I deemed him Uncle Drew because I know how you fight for those victims and all that. You had my back, Duke said in the video, until my last memory was me waking up in his room. The allegation is part of an investigation by Las Vegas police, but Holmes has not been charged. Last month, at a separate meeting, 4 trustees voted to hire former Chicago Mayor Lori Lightfoot to dig into Henyard's handling of village money. Henyard has also not been charged with any wrongdoing. I am vetoing everything into secret squirrel meeting. I think that's hilarious. Secret squirrel meeting. Henyard said, now that the subject of an FBI investigation, the South suburban village sinks deeper into chaos. So, does Miss Tiffany Henyard qualify for qualified immunity? Did she act knowing that she should not have done certain protections, certain things, certain established rules, policies, and laws? Did she act that way? We'll find out. Stay tuned to do. We're all interested in this. Remember, she is a community individual or hired by the community, or government official, I should say. All right, so let me know your thoughts, your opinions. I hope I answered a lot of questions there. And thanks for that. And I do try to read the comments and all that. And if there's clarification I need to give, make sure you do it. If you made it this far into the video, please make sure that you give me a like. Please hit that thumbs up or thumbs down, right? If you don't like it, you don't think I did a good job, that's great. I always try to improve, but please make sure that you hit that thumbs up. If you made it this far, please make sure that you hit that thumbs up. It's very, very important.